Okay, good afternoon, everybody. Welcome to the 101st branch meeting of the UAE IRSM branch. My name is Peter Hurley, and today is the 12th of January. We've got quite a full agenda ahead for you. I've got quite a few branch updates, and then we'll be having a very brief word from the Middle East and Asia, I think, IPAF representative, Jason Woods, who's agreed to join us at very short notice. And then we'll be having our main presentation from Samantha El-Abi from Clyde & Co. And she'll be looking at the liabilities and the various do's and don'ts following a workplace incident. And we'll wrap up with the usual, any other business, and close with some questions and answers as well. Okay, so without any more delay, let me proceed. So a little bit of an update on the current situation with COVID-19. There's lots developing at the moment. It's quite a fluid situation, but there have been amendments made to some of the controls around the testing requirements. So to maintain your green pass on Al Hassan now, if you're vaccinated, you need to do a PCR test once every 14 days, and obviously that needs to be negative. And then for any employees of government authorities, government organisations, government companies or government-owned companies within Abu Dhabi, there is now a requirement that you are tested once every 7 days. So there's some updated requirements there. I know there are other requirements being issued through circulars by various different authorities as well, but I'm just raising those as the two main ones that are critically affecting most of the working population and the general population. Okay, the LinkedIn page continues to grow. We're now up to 860 followers. Sorry, that has been copied in twice, but I encourage you all to visit and use it. It's growing as a resource, and I'd ask you to all encourage your network users to follow it as well, so we can really grow some critical mass with that page. And it's awards season as well. So the applications are open for the IRSM Risk Excellence Awards 2022. The closing date is the 18th of February. So there's still time if you want to put yourself or an esteemed colleague or an organization up for consideration for the various different awards. It's an excellent event, and it will be one worthy of your time and participation. So please look at that, and if you think that there's a category which you meet, or you know somebody who meets it, put yourself forward or recommend that that your colleagues put themselves forward for it. Okay, we've also got a new training scheme from IRSM, Managing Risks, the Essentials. And this is an online course over 2 sessions of 120 minutes over the course of 2 days. The first session will be on the 9th and 10th of February, and then again at the start of April and the start of June. It will be done entirely online, and it will be from 9 AM to 11 AM UK time. So for the February, that will be 1 till 2 here in the UAE. It will be held on GoToTraining, and there is a cost involved, which I understand is 175 British pounds, which translates at around about 875 dirhams. So it is a recognised course from IRSM. It's well worth your participation. And also we have upcoming this year, IPAF undertaking 6 training courses through 2022. They are planning to have both in-person and virtual courses and virtual attendance. Now, there are limited spaces, but Jason has told me that they are looking at having 10 seats available for IRSM members to attend the in-person training. And the first one's going to be on the 9th of February in the evening at JSP Products in Jebel Ali in Dubai. And it's going to be about tyres, understanding your limits. Now, I believe Jason's here with us now. Jason, do you want to say a few more words about it?
Yeah, just first of all, can you hear me, everyone?
Yes, yes, we can hear you, yeah.
Okay, so just a very brief outline. I just feel that there's still a bit of a gap in the market of technical knowledge, meaning tires, for a good example. I think we shared something on the group a few months back, or at least a few weeks back. So that kind of triggered off the need then for these kind of technical sessions. So it will be in person, but the seats are limited, Pete, like you say. But we have the ability to streamline it to others and include in other chapters of IRSM as well. So the idea is that everybody can enjoy the sessions, but there will be at least 10 seats for the moment available for in person if anybody would like to attend and have kind of a one-to-one. But it will be hybrid, so if anybody doesn't have the chance to sign up, then we can still run it through a virtual platform as well. These sessions will be dedicated to technical, so just off the top of my head, we're looking at tires, ground conditions, how to read slopes and relate it to a tilt sensor on a machine. Just to give a little bit of added knowledge of working at heights with elevated work platforms. That's the concept behind it, Pete, and the thought.
Okay, sounds good. So what should members who are interested do? Should they email you directly, or can they get in touch with me and I'll let you know?
Can either way. I don't mind whichever way. I really don't mind. But whatever's easiest, I think, Pete.
Okay, and is there information about these courses on the website?
Not yet, so we're still building on it, but we are set for the first session on the 9th, evening of the 9th of February. That will be the first one, and then it'll kind of be every 2 months then we will run into this.
Okay, great. So if there are people out there who are interested, you can email Jason there at his email address, jason.woods@ipath.org, or you can get in touch directly with myself via WhatsApp, and we'll be posting some updates about that as we get closer to the event on the WhatsApp group. Okay then, Jason, thanks very much for popping in and saying a few words. Appreciate it.
I'll sit in the background and listen anyway, so thanks, Pete.
Okay, yeah, that's great. All right, Jason, take care.
Thank you.
Thank you. Okay, some upcoming events. There's a branch meeting in Oman today. I'm not sure if that's going on now or later on tonight. And then there's other regional branches taking place throughout the rest of January and into the start of February in the new Saudi branch, Qatar, Egypt, and again in Oman on the 2nd of February. Also in the UK, upcoming this month will be the West Midlands and the London branch meetings on the 13th and 19th of January. So if you're interested to see what is going on locally, regionally and internationally, you're free to attend those. They are also recorded and will be available on the RSM website and on the YouTube channel if you're unavailable when they're live. And we have some professional development sessions in the pipeline as well. Some of these I've previously covered, but we've got diversity of people and thinking and impact of risk coming up tomorrow, that is, in fact, followed by integrating risk and the ISO standards, and then a mentoring session on the 20th. There's a couple more planned into the schedule in February concerning governance and also mapping stakeholders before, during and after a crisis. And those are the only ones that I've included in terms of what's upcoming. There's plenty more in the pipeline. If you go onto the IRSM website and click on events and then click on professional development, you'll see the list of events that are coming up. So there's lots of good stuff, lots of good content that's being made available by RSM to you, the members, and it's all there for your professional development as well. So it all counts towards your CPD, but it's well worth dipping into as we expand our knowledge and open our horizons. And just an update on the schedule that's planned through to May. So next month we'll be covering safety in the heat, and we've also got a brief session on tyres and mutes. So that will tie in neatly with Jason's forthcoming session with IPATH. In March, we'll be looking at the UAE branch committee itself, what the roles and functions are, and we'll be meeting a few more of the committee members because whilst we've been living in this virtual world, you've just been seeing my face and hearing my voice. And whilst that might be blessed for some of you, perhaps it is time that we met some of the other committee members as well. But also with the AGM and elections coming up in May, it's time for you, the members, to start to think about who you want to have on the committee and whether you want to be on the committee. So I think the best way of doing that is to give you a better understanding of what's involved in being on the branch committee, how the branch runs, and whether you'd be a good fit if you feel that you want to put yourself up as a nominee when the elections come around in May. We're still open in April, so if there is anybody out there who's got a particular topic that they want to be covered or has a particular topic they'd like to present on, knows of a good resource that would be worthy of presenting to the branch, then please let us know at the committee or make a suggestion on the WhatsApp group, and we'll be filling that slot in the next couple of weeks, hopefully. So do get in touch and let us know. We'll also look at ideas for the June and July branch meetings so that the new AGM are not caught cold with needing to plan anything quickly. So again, if anybody's got any thoughts and suggestions of presentations that could be provided in June or July, please let me know. Okay, that's enough for me for the moment. It's my great pleasure to introduce to you Samantha Ellaby from Clyde & Co. And she's going to give us a presentation regarding some of the practices to follow and to avoid when you have a workplace incident. Samantha's from Clyde & Co. And Clyde & Co have provided partnership support to IRSM for many years now, including sponsorship at key events and presenting at key events. So we're very pleased to welcome back an old friend. Over to you, Samantha.
Thanks very much, Peter. Hi, everyone. Hopefully you can see my screen. Can you see that okay?
Yes.
Great. Okay. So, yeah, as Peter said, we're going to talk today about the liabilities that can arise following a workplace injury and the do's and don'ts. So, based on...
Sorry, Samantha. Can you just share your screen again, please? I can see you, but I can't see your screen.
Oh, yeah, we get them.
Hang on one second. Perfect. Yeah, thank you.
Okay. And just by way of brief introduction to me, so as Peter said, I'm a lawyer with Clyde & Co. I'm an employment lawyer, but I also lead the firm's health and safety practice. And so I advise clients on liabilities that can arise where there is a workplace incident, and also support companies with litigation, so the criminal proceedings, the labour claims, the civil claims that can arise following a workplace injury. So I'll share some of those experiences with you today. Before we can get into the liabilities that arise, there are a few important questions that we need to ask. The first, and I suppose most important one, being where can I find a health and safety law? So where do I look to work out what liabilities can arise following a workplace injury? And you know, in your capacity as health and safety professionals, I'm sure you'll all know that there is no dedicated health and safety law here in the UAE. Instead, there are health and safety provisions set out in a wide range of different pieces of legislation. And so, as I've tried to show on the slide, it's almost a pyramid where you have the overarching Sharia principles. You then come down to the federal legislation which applies across the UAE. So you have the key ones being the penal code and the civil code from a health and safety perspective. We then get down to the employment legislation, so the labour law or the DIFC or ADGM employment rules, depending on where the company is based. And then beneath that, we have free zone rules, we have ministerial resolutions, we have emirate or sector-specific rules and regulations. And so what that means really is that there's often not one single answer to a question relating to health and safety. So one of the questions we're quite commonly asked, for example, is when do you need to report a workplace injury? And there are several different answers really, depending on where the company is located, whose jurisdiction they fall under, and whether they are regulated by a specific regulator. And what you'll often find is that a company will be subject to the labour law, for example, which has specific obligations in terms of reporting, but perhaps might also fall under OSHA's remit, which has different rules around reporting and when that obligation is triggered. And what we also see quite commonly is that where you have companies that perhaps have an entity in Abu Dhabi and an entity in Dubai, there will be slightly different rules that apply to them. So, I mean, I guess it's a good thing for me as a health and safety lawyer, because it means that actually it's quite complex. It's not so good for those who are trying to get their head around the health and safety legislation. And I guess an added complication here, as I'm sure you'll know, is that there isn't a central database that you can look to find all of these laws. They're only published in Arabic officially, so it can become very tricky actually to answer what should be a very straightforward question. So the next question that we need to ask ourselves is, what is a workplace injury? So when does an injury that's sustained by an employee become a workplace injury? Now, clearly, injuries that are sustained in the workplace themselves whilst an employee is performing their work will be a workplace injury. But what if it happens whilst an employee is on a client site, or is travelling overseas on business, or is at a work-related party or event? And likewise, what happens where someone is injured on your site? So if a subcontractor is injured whilst working on your site, and that's where it all gets slightly more complicated. So I guess going back to where the laws derive from, it follows therefore that there is no single definition of a workplace injury, and the answer very much depends on which legislation you look at. I've set out the definition there of a workplace injury under the current version of the labour law. I should say that there is a new version of the labour law which will come into effect on the 2nd of February, which has a slightly different definition, although broadly the same principles. So you'll see that this definition is actually really broad. So it talks about injuries arising from the employee's work, as you'd expect, sustained by the employee while performing their work, again, as you'd expect, but also as a result of such work. And that's where the definition is really broadened, because it's not just whilst you're performing work, it's as a result of such work. And I'll come on to some practical examples of what that means shortly. The other point to note is that the definition also includes injuries that are sustained whilst travelling to and from work. unless there is a diversion in the journey. So if an employee is driving from their home down Shakespeare Road to the office and they have a car accident whilst driving their own car, nothing to do with the company, that would still be a workplace injury within the meaning of the labour law, because it's whilst they were travelling to and from work. If you apply this definition very strictly, then if they stop off at the petrol station on the way and they're injured whilst driving from the petrol station to the office, that wouldn't be a workplace injury, because there's been a break or a diversion in the route. So a very, very broad definition, and often circumstances that actually as an employer you have no control over. The other very important definition is the one that's set out in the penal code. So on the slide I've set out Article 343. There's also which relates to injuries. There's also an equivalent with broadly the same wording which relates to death. So you'll see that this definition, which effectively outlines the circumstances in which a crime takes place, is where an individual by his fault causes injury to another person. And it goes on to talk about a crime being committed as a result of the offender's failure to perform the duties imposed on him by the principles of his profession or craft. And so when some of you may have had personal experiences of this or heard of this, but what quite commonly happens following a serious workplace injury or fatality is that the police will become involved and there will be a criminal investigation and ultimately criminal charges made. And this article or the equivalent article that relates to death is what the police, the public prosecutor, and ultimately the court are looking at. So what they will want to establish is who had a professional duty to protect the health and safety of the injured or deceased party, and was that professional duty properly discharged? Was there any failure in that regard? And so, again, it is a very broad definition, which is applied very broadly, in my experience, by the court. So what the court will typically be looking at is effectively whether that person or sometimes multiple people took all reasonable steps to prevent injuries of this nature occurring. So what does that mean? I mean, I guess it somewhat depends on the circumstances, but typically, were there safety signs in place warning against this danger, or warning not to do or to do a particular thing? Were there policies and procedures? Were employees, and specifically the deceased or injured employee, properly trained? And it goes further than that. It's not a tick box exercise. It's not sufficient to say, well, yes, we've got this policy, or yeah, we train employees as part of the induction. If you've got a policy, how is that made available to employees? Was the employee simply notified of it on commencement of employment 10 years ago, or is it regularly recommunicated to the workforce? With training, is that something that just takes place on commencement of employment, or is that a regular occurrence? And also another factor that I've seen be very relevant where there is litigation is how that information is presented. So at a very basic level, there's no point in having safety signs or a health and safety policy that's written in English if that's not a language that's understood by the majority of your workforce. And equally, if you have a workforce that comprises of individuals who have low literacy levels, and thinking about the way that information is presented through diagrams, etc., rather than a 50-page health and safety policy, is also very important. So when you get to the court, it's about the steps that the accused has taken being meaningful and not just having the policy, having delivered training. I'll come on to kind of do's and don'ts and common pitfalls towards the end, but this is such an important point, I want to repeat it. But the key thing that I see go wrong in these sorts of claims is that there is insufficient evidence that these things have happened. There has to be written evidence, otherwise it may as well not have happened. So quite often clients will say to me, we do daily safety briefings, and this is something that's discussed in the daily safety briefings. But because they're daily safety briefings, there's no record of that having taken place. There's no slides. There's no attendance record to say that the employees attended it, and so it's effectively like it didn't happen. If you can't evidence that it happened, the court won't give any weight to it. So I mean, clearly it's not practical to take minutes of every kind of daily safety briefing that you do, but it is important to keep in mind the importance of written documentation. So having training records, making sure that everything is retained on file. So I thought it might be helpful just to run through some practical cases that I've dealt with, just to flesh out a little bit more the circumstances that can lead to liability following a workplace injury or fatality. So usually I would do this as an interactive slide, but I think you're all on mute, so I'll help you and give you the answers as well. But please do have a think about it. So the first scenario is a question that I was asked by a client. So an employee was actually at a Christmas party that was held at a hotel. It was late on in the night, and the dance floor was covered in drinks that had been spilled and also glass that had been broken. The employee slipped on the dance floor and actually very severely lacerated his wrist. And so the company called me after the weekend and said, what do we do about this? Is this a workplace injury? Could he claim compensation? The other relevant point that I've put in the slide there is that this employee was under the influence of alcohol at the time that the incident took place, and obviously that was a key thing that the company wanted to understand, was whether that had any impact. So was this a workplace injury? Well, yes, potentially, and the reason for that is if we go back to the definition of a workplace injury under the labour law, it's injuries that are sustained as a result of work. This is a work arranged party, and so there is certainly a possibility that this could be a workplace injury. And actually, just to skip ahead to one of the other examples, because this one actually went to court. So the third scenario I've put there is where an employee is injured whilst participating in a desert safari. And the desert safari was organised and paid for by the company, so it was a staff social event. But obviously, it was a third-party company that actually conducted the safari. And this went to court, and the court found that it was a workplace injury. Even though it happened outside of working hours, it was simply organised by the company. It was a third-party desert safari company that effectively administered it. Because they said that as an employer, you have a duty under the labour law to provide recreational facilities to employees. actually that obligation only applies to companies that are in remote locations. But nevertheless, the court said, as an employer, you have an obligation to provide recreational facilities. That's what the employer was doing. Therefore, it's related to the employee's work, and so it's a workplace injury. So I think if you then look back at the first example that I was asked about, could an injury sustained at an end-of-year party be a workplace injury? Yeah, I think so. The fact that he was under the influence of alcohol is relevant. So there is an exemption to the obligation to pay compensation under the labour law where an employee was under the influence of drugs or alcohol. The issue really is proving that. So he may have been under the influence of alcohol on Thursday night when the incident happened. But obviously that wasn't the company's main priority at the time, evidencing that he was under the influence of alcohol. Their main priority was, seeing to his immediate medical needs. And by the time they contacted us the following week, there was no way of evidencing that he was under the influence of alcohol at the time. Another couple of examples, so again, the second one is a case that I dealt with, whereby an employee had protective goggles. He was working with acid, for whatever reason, at the end of the day, he'd put those goggles on the top of his head. Something had dropped into the acid and splashed back into his eye. Was that a workplace injury? I mean, yes, clearly it happened in the workplace whilst he was performing his work. Was the fact that he wasn't wearing his protective goggles relevant? Yes. So again, there is an exemption under the labour law to liability under the labour law where an employee fails to follow clearly displayed safety instructions. So the key thing for this company before the labour court was showing the safety signs, the training that it had provided, stressing the importance of wearing the PPE. And then the last one I'll just run through, an employee was injured whilst walking into work. Actually, this is a slight exaggeration of a real life case that I dealt with, but in my slightly exaggerated example, an employee is wearing a new pair of high heel shoes. She walks into work, she falls and she injures her knee. Is that a workplace injury? Yeah, under the labour law, it certainly could be, because she was travelling to work. So as long as there wasn't a break or diversion in her route, then that could be a workplace injury. The issue actually that the company had here was that she didn't report it at the time. It was only later, when she'd had issues with her knee for quite some time, that she said, actually, this is all because I was injured whilst I was walking into work, and it's a workplace injury, and so I want compensation. And it became very difficult for the company then because they didn't have any contemporaneous medical evidence. So I would always encourage companies to have internal policies on when to report injuries, and really to encourage employees to report any injury that could potentially be a workplace injury. So, when it's traveling to and from work, whether it's at work events, whether it's whilst they're traveling with work, so that you as a company can make a decision as to whether it is a workplace injury, whether you should get medical evidence, whether it should be reported, etc. So we now get to, what does it mean if there is a workplace injury or fatality? What does that mean? Who can be liable, and what does that liability look like? So again, there isn't one answer really. The answer is that in relation to a single workplace incident, we often see multiple types of liability arising, often for different parties, and you often see litigation running concurrently in the labour court and the criminal courts, and ultimately sometimes claims being raised in the civil courts as well. So if we look at the liability under the labour law first, so that liability would only ever apply to the employer of the injured or deceased party. That liability extends to paying for the employee's medical treatment, paying the employee's salary if they're unable to work, and that's at full pay for the first 6 months and at half pay for the next 6 months, unless the employee recovers or is proven disabled in the meantime. And then the third element is compensation, where the incident results in death or permanent disability. Under the current labour law, that compensation is capped at 35,000. So under the current labour law, even in the case of death or permanent disability, the maximum compensation that the employer can be ordered to pay, purely from a labour law perspective, is 35,000. The current labour law was written in 1980, when 35,000 equated to more. Obviously, in today's world, 35,000 is extremely low in terms of compensation for death or permanent disability. In the new law that's coming into effect next month, the cap has been increased to 200,000. So you've got your maximum compensation for death or disability, and then under the current labour law, there's a schedule which basically sets out a percentage of that maximum depending on the injury. So there's a specific percentage for losing, your thumb or your right leg or your arm. So it's a very kind of crude assessment of what have you lost, or what have you lost the use of, and then it's just a set percentage. And we're still waiting for the implementing regulations for the new labour law to understand how this is going to work going forward. And I've mentioned there that there are some exemptions to the obligations to pay compensation under the labour law. In addition to potential liability under the labour law, I suppose the liability that's often key when I'm speaking to clients is the criminal liability. And the reason that this is often key is because it obviously potentially impacts on someone's liberty. It has the potential to result in an individual going to prison. Liability under the penal code will typically fall to an individual, and going back to the definitions that we talked about in the penal code, that individual will be the person that the police, public prosecutor, and ultimately the court consider to have been responsible for protecting the health and safety of the person that has been injured or deceased. So that will very much depend on the nature of the workplace. It's typically the site manager, the project manager, sometimes the general manager, and sometimes the health and safety manager. But it very much depends on the workplace. So where criminal liability is found, there can be the potential for fines or imprisonment, and also the payment of blood money or injury money. And really, my experience is often that the authorities there's a desire often to find someone responsible, because without that, the injured party or the deceased party's estate don't get their blood money or injury money. And I think it is quite helpful sometimes to have that in mind, that the public prosecutor is often very keen to pursue prosecutions to ensure that the victim gets their blood money or injury money. And then the final litigation that we often see arising out of workplace injuries or fatalities is civil proceedings under the Civil Code. So there are various provisions that can be triggered, and I won't go into all of them, but there is one provision that talks about there being an obligation to make harm good effectively. So it's very broadly drafted and can often be relied on where someone has suffered an injury or fatality to claim civil compensation. Civil compensation can be claimed in addition to labour law compensation and in addition to criminal penalties. The civil liability can fall to an individual or a company, but given it's typically a claim for money, the claims will often be raised against a company because companies typically have deeper pockets to satisfy any award. And what we often see in practice is that you will have the criminal proceedings. An individual within the company will be found criminally responsible, and then off the back of that, the victim or the deceased estate will bring a civil claim against the employer under the vicarious liability provisions, saying your employee has been found criminally responsible, you are vicariously liable for acts of your employees, therefore you need to pay us compensation. And then finally, you sometimes see administrative sanctions being imposed. So there's the ability for the ministry to impose fines for breaches of health and safety obligations under the labour law, and also for various regulatory bodies to impose fines or sanctions, depending on who the company's regulator is. So looking then at the criminal investigation process, which I think it's important to understand to come on to my last point, which is really around do's and don'ts and common pitfalls. And you know, some of you may have been through this already. You know, it's I'm sure anyone that's been through a criminal investigation process following a workplace incident will agree that it's not a pleasant process, and you know, I guess at the root of it all, you will have a colleague who's been injured or who has died, but also the process itself it can be very tricky. But what I do find is that actually it's such a good exercise to go through the process. You always learn from it. There are always things that with hindsight you realise you could have done differently. And so I think it's really important that those involved in health and safety, but also senior management, are aware of what happens where there is a workplace incident, so that you're not learning as you go, that you're prepared, you know what to expect, you have a plan. So what does the criminal investigation process look like? The start is the police, but often it's not just the police. Often in the immediate aftermath of a workplace incident, the police will attend, but also potentially the ministry or whoever your labour regulator is. If you're regulated by a particular regulatory body, civil defence, you know, often it's quite chaotic, frankly, because you have representatives from different authorities all trying to do their respective investigations. The police will take statements. They will sometimes retain passports for the persons that they deem to be responsible, and sometimes those passports are retained for the duration of the criminal investigation process. So until we have the final outcome from the court. Often this is where I find things go wrong. So I often find that we're instructed once the matter goes to court, and obviously, you know, before that you've had employees that have given statements to the police and public prosecutor and handed over documents. And it's the police stage in particular that I often find things have been said or done that aren't very helpful to the case. And I suppose part of that is it's a really emotive situation. But what I commonly see is individuals inadvertently admitting responsibility. And to give a good example of this, I was involved in a case where it was a very small company. Quite a young employee had been seriously injured when his hand went into a machine, and he'd lost 2 of his fingers. The general manager in this case was the individual who was facing the criminal proceedings. And when I spoke to him, which was after he'd given a statement to the police, he was saying to me, I feel very morally responsible for this. It was a young lad, perhaps he shouldn't have been working on this piece of machinery. I feel morally responsible. And it transpired that that's effectively what he'd said to the police. But his statement didn't say, I feel morally responsible, I'm not criminally responsible. It just said, are you responsible? Yes. It's very difficult to step back from that. When we get to the court, we've then got a statement that the individual has given to the police that says, I am responsible. So I guess this is why I say it's so important to have a plan, so that when you are in this very emotionally charged, chaotic situation where employees are being asked to give statements, you have a system in place. You have a notification process. You know who within the company to contact. You have someone that's going to coordinate the statements that are given. You have an Arabic speaker who's going to attend the interviews. So if the police deem that there's a case to answer, the matter then gets passed to the public prosecutor. I have seen cases where the public prosecutor just refers it straight to the court. So you can't rely on having an opportunity to make further representations and submit further documents to the public prosecutor. But typically the public prosecutor will conduct its own investigations. It will carry out further interviews. It will request further documents. I suppose often its investigations will focus on the person or persons that the police have found to be responsible, but not always. The public prosecutor will sometimes take a different stance. That part of the process can sometimes take some time. Often the public prosecutor won't start its investigation until the condition of the injured party is stable. So we've been involved in cases where that has been, a year or more down the line. And that can obviously be quite challenging because memories will have faded in that time. And so what was said to the police isn't necessarily consistent with what's then said to the public prosecutor, and that becomes an issue in the court. When you give a statement to the police, you don't get a copy of your statement. You often won't see that again until the matter goes to court. So it's really important that there's some coordination and that there is someone in charge of collating what has been said to the police, what has been handed to the police, so that if you are in a situation where the public prosecutor stage is, months, years down the line, you've got some record of what's already out there. And then finally, if the public prosecutor finds that there's a case to answer, they will refer the matter to the court, and it's the court that ultimately has jurisdiction to make a criminal finding of guilt or not. An important point just to keep in mind is that it's the public prosecutor that effectively brings the criminal proceedings. It's not the victim or the deceased party's estate. And what clients often say to me is, the victim, is happy to accept this settlement offer. We've paid them X amount, so can we now make this criminal case go away? And the answer often is no. The public prosecutor will take into account sometimes the fact that a settlement payment has been made and that the victim has been properly compensated. But if they think there is a public interest in the case proceeding to court, it will still proceed, notwithstanding compensation has been paid. And actually, I've seen it be used against the individual by the public prosecutor to say, you've paid compensation, clearly you must therefore have been at fault, and so the court should find you criminally responsible. There are 3 stages in the criminal court. So the first instance, the Court of Appeal, and the Court of Cassation. It's really common for cases to be appealed to the Court of Appeal. You see that almost in every case I've dealt with, and not so common for it to go to the Court of Cassation. And then just a few key points I wanted to highlight in relation to the court proceedings themselves, which I think are important to keep in mind because it really drives what you do before you get to that stage. And I think the key thing is, that those of you who've been to the courts here will have seen that it's nothing like these very exciting court cases that you see on TV. So typically there will be several health and safety cases all scheduled for 10 o'clock. Everyone will sit on their benches in front of the judge. Each case will get called up one by one, and predominantly the advocates from both sides will just submit documents. They'll say a few words in Arabic, but there is very limited opportunity to give detailed oral evidence. Witnesses are very rarely called, which is why the written documentation is so important. In common law jurisdictions, if you didn't have a document that showed that the employee had been trained, for example, you would get witnesses to stand before the court and say that they all witnessed this training happening. You won't get an opportunity to do that here, and so it needs to be in writing. The other important point, which I always stress to companies when I'm involved in these matters, is that there is no system of binding precedent. So, of course, when you deal with these matters time and time again, you get a feel for how the courts will interpret things and how to present things. But each, you could have 2 cases with exactly the same facts, go to the court and reach 2 completely different decisions, and that makes the process very unpredictable and obviously very difficult for those involved, where you're potentially looking at a custodial sentence. So finally then, and I've talked about some of these as I've gone through, but I just wanted to highlight some of the common issues that I've seen in the cases that I've dealt with. So the first one I've mentioned already, but it really is the one that I see go wrong most often, which is inadvertently admitting responsibility. And I think, like I said, I think in some cases there is a sense of responsibility. There's a sense of moral responsibility, but that distinction is never going to be recorded in your statement. So you have to be very clear that you are not criminally responsible. The other issue, I think, sometimes is that often these interviews will be conducted in Arabic. There is sometimes a lack of understanding of what you're being asked or what you're being asked to admit to. And you obviously need to manage that. Ideally, you would have an Arabic speaker with you. But if you don't have an Arabic speaker with you, then you just need to be very clear about what you're being asked and how you're answering. I actually think, clearly you need to be cooperative with the authorities, and I would never suggest otherwise. But I think there is sometimes a tendency to overshare. I think typically there will be nerves involved, there will be emotions involved, and also a desire to help. And so I think there's sometimes a tendency to over talk rather than just answering questions, where the better approach really is just to answer the questions and leave it at that. The other thing that I've seen is, and I think again this happens when you start to kind of overspeak, is that you start talking about hearsay rather than facts, and that, you know, it's not helpful. You don't need to share it. It's much better to just stick to the facts. And if you don't know the answer, just say you don't know. Say you weren't there. You know, that's totally fine. I've said consider what documentation to share. So again, I'm not in any way suggesting that you withhold documentation from the authorities. You know, clearly, if you're asked to share a particular document and that document exists, then you should share it. So this isn't about being disingenuous. But again, beware of oversharing. So share what's asked for. But if it's not asked for, think about whether it's helpful to your case. So to give an example, I was involved in a case where in the aftermath of the incident, the company quite naturally had prepared a very detailed report looking at what had happened and what they would change going forward. The police, the public prosecutor, asked for the incident report, the investigation report, and this full report was shared. And those points around the things that they would change going forward was used against them in the court proceedings to say, clearly you must have done something wrong because you're looking to change all of these things. A better approach would be to have two reports effectively. So you have your incident report, which is purely facts, this is what happened, and you have a separate internal document which looks at things that you know, learning points and things that you might change going forward. And then if you're asked to share the incident report, you share that. You know, you're not withholding information, you're sharing exactly what's been asked for. You don't necessarily need to disclose the steps that internally you've decided to take going forward. And then the final one, I guess, which again I've touched on, is taking a unified approach. So, you know, often there will be lots of employees interviewed as part of this process. You need that all to feed back to a central person so that there is some oversight over what's been said and what's been handed over. So what can you do to prepare for the worst? Have an emergency response process. So as I've said, you know, you don't want to be learning this on the job. You know, you want to have a plan in place so that if there is a workplace incident, you know exactly, you and, you know, relevant employees know exactly what to do. So who do you call? Who's going to come on site? Who's not going to be on site? Who's going to be the lead contact with the authorities? You know, have all of this prepared, ready. As I've said, I think it's really important to train management and relevant employees on what to expect if a workplace incident occurs. So, you know, effectively this, you know, what does the criminal investigation process look like? What should and shouldn't you do? Provide training on health and safety to staff. You know, that I don't typically see that being an issue. Often the training is provided, but the key thing is making sure you've got documentary evidence of that, thinking about the way that training is delivered and the frequency within which it's delivered. Yeah, and then know the law. So yeah, just being informed, I suppose, and making sure that your employees or relevant employees are informed. I think I've gone a little bit over my time, but I'm very happy to answer any questions.
That's not a problem, Samantha. We were late starting anyway. Well, that's excellent, Samantha. Thank you very much for that presentation. I'm somebody who considers themselves to be a bit of a know-it-all and to be a bit of a know-it-all when it comes to incidents in the workplace, but I've certainly learned lots and lots there. especially coming from perhaps the other angle that safety practitioners don't really consider, which is one of the prosecutor and the legal standpoints, and the sort of minefield that we might find ourselves having to navigate. But from a safety professional point of view, I think some of the key takeouts there come down to having your ducks in a row in terms of making sure that you have appropriately documented your processes and your procedures in terms of training, in terms of control measures, in terms of procedures, so that you have that record and you have that evidence to demonstrate that there was at least an element of care and preparation to undertake tasks safely and effectively. I'll just defer to Donna to see if there are any questions.
Not yet, Peter.
Okay. So I understand we've had one about the IPAF courses, Donna.
Correct. Yes. Yeah. Someone was asking what the 6 courses would be about.
Okay. So Jay, is that you, Jason?
Jason's not on the line anymore.
Jason, oh, so I heard somebody in the background. Okay. So well, the first session will be on tyres and know your limits, as discussed. The second will be a discussion on slopes, including tilt alerts and what responsibilities MUPE owners have to check, including how to read a slope related to the maximum gradient of the MUPE, sorry. And then the third will be understanding the relationship between fall protection, focused on safety harness and anchorage points. The last 3 sessions are yet to be confirmed. Okay, so they're going to touch on various different aspects of working at height using MUPEs or powered access. Okay, do we have any other questions, Donna?
Yeah.
Does anybody have any questions for Samantha?
Yeah, I've got one question here. What does the law say when it's clearly identified that the employee has been responsible for the accident?
Yeah, so I guess if we work through the different types of liability, so for under the labour law, it doesn't really matter unless one of those exemptions is made out. So unless they've failed to follow clearly displayed safety instructions, unless they've refused medical treatment that they should have taken, unless they were under the influence of alcohol or drugs, etc. It doesn't matter. It's just, was it a workplace injury or not? So it's what's referred to as strict liability. So it's not fault based on the employer. It's just, is that definition made out? Have any of the exemptions been made out? If not, it's a workplace injury. When it comes to the criminal liability, the fault of the victim is relevant to an extent, but it's not an absolute defence, because the questions will then be, well, how was this able to happen? So to give you an example, I was involved in a case where an employee had fallen asleep in a no-go zone on a construction site and had been killed when some debris fell on him. So he was clearly at fault. He'd gone into a no-go zone, and that ultimately was the cause of his death. But there was still a criminal prosecution, because the question was, well, how was he able to go into a no-go zone? Were there signs? Were there barricades? How was he able to just slope off and no one knew where he was? You know, is there no kind of attendance system in place? So it's not as simple as they're at fault. How were they able to be at fault in the first place? You know, did they know that they shouldn't be doing this?
Thank you, Samantha. And I'll just add in there as well, from a non-legal but a regulatory standpoint. I think you should be very careful if you're going to approach an incident in terms of assuming or with a prejudiced attitude that the injured party was at fault. Now, they may have made a mistake. There may be an element of liability on their behalf, but as Samantha says, you start doing the investigation against health and safety principles, and you'll be asking yourself why. So it might be that you say, oh, well, he wasn't supposed to be doing this job, or he wasn't appropriately competent for this job. Well, the question then is, well, why was he doing that job? Or what is your competency assessment the situation in terms of ensuring that somebody is appropriately competent to do jobs? So you are employing people, you are inviting them into your workplace, you are asking them to do jobs, and you're paying them for it. Your responsibility is to ensure that they're trained, competent and safe to do so.
Brilliant. Thank you.
Do we have any other questions, Donna?
That's it. There isn't any other questions that have come through.
Okay, excellent. Well, my thanks once again, Samantha. Really good presentation, and I think it's provided a lot of good information for our members to take away with them and to take back to their companies to ensure that they are appropriately prepared if the worst does happen. So I'd like to, I'd like to
share the slides if anyone wants.
That would be great. That would be great. Okay, so thank you very much again, Samantha. Okay, Donna, if you can just let me share my screen, and I shall just wrap up.
There you go, Peter.
Okay. So the usual, any other business, we still have lots of merchandise available. If people are interested in obtaining some, please drop me a message or get in touch with any of the committee members, and we'll arrange collection or delivery. And just finally, our usual social media and communications slide. The WhatsApp group is available. It's nearly full, but it's not full. So if there's anybody out there who wants to join, please let me know. We're on Twitter with a Middle East handle, ME_IIRSM. There's the email for those of you who are still stuck in the 20th century. And there's an active YouTube channel as well. And then finally, of course, don't forget to refer to the IRSM website. My top tip for today is I always have it opening up when I open up my web browser at work, so that it's there for me to log in and get my updates and find out what's going on. And then, of course, there's the LinkedIn page. So please do follow that if you're not already. And if you can do one thing tomorrow when you go into the office, sign on to that LinkedIn page and then invite as many people from your network to follow that LinkedIn page. Let's see if we can get the numbers up to 1,000 by the time we meet in February, which will be on the 2nd. So we're only 3 weeks away from the next meeting, which will give the committee some food for thought. But I look forward to seeing you on the 2nd of February. And in the meantime, I thank you for your time and attendance. I wish you all a very happy and safe evening. Thank you.
Brilliant. Thank you, Peter. Thank you, Samantha, and thanks to Jason as well. And we look forward to seeing you next time. Thank you, everyone, for attending. Take care.